Hey everyone, divorce can be a highly emotional and challenging process, but one of the most crucial aspects that must be settled is the division of matrimonial assets. If you and your spouse can agree on how to divide your assets amicably, the entire divorce process can be smoother, faster, and much less stressful in an uncontested divorce. In this video, I'll break down the division of matrimonial assets in simple terms, explain what the Women's Charter says about it, and give you practical advice on how to discuss and agree on asset division before filing for an uncontested divorce. When a couple gets divorced in Singapore, their shared assets, commonly known as matrimonial assets, must be divided fairly. This process is governed by Section 112 of the Women's Charter, which states that the court has the power to order the division of matrimonial assets in a just and equitable manner. Matrimonial assets generally include the matrimonial home, whether owned by one or both parties, and any properties acquired during the marriage, savings, investments, and CPF funds accumulated during the marriage, cars and other valuable possessions purchased during the marriage, businesses or shares in companies owned or co-owned by either spouse, household items and furniture, and any other assets acquired during the marriage that were used by the couple or their children. However, some assets are not considered matrimonial assets. Property or money inherited from parents or received as a gift is typically excluded unless it was used as a marital home or for the benefit of the marriage. Personal belongings like clothes, jewelry, or sentimental gifts not acquired jointly also do not fall within the pool of matrimonial assets. When dividing assets, the court considers factors such as the extent of financial and non-financial contributions made by each spouse, the needs of any children from the marriage, the length of the marriage, and any agreements made between the couple before or during the marriage, such as a prenuptial or postnuptial agreement. If you and your spouse want to proceed with an uncontested divorce, one of the most important things to agree on is the division of matrimonial assets. Both spouses should sit down and create a list of all assets that will go into the matrimonial pool. This includes properties, bank accounts, investments, CPF funds, vehicles, business interests, and valuable items. It is important to be completely transparent at this stage, as hidden assets or dishonesty could lead to disputes later, potentially turning an uncontested divorce into a contested one. Once all assets are listed, discussions should take place to determine who will keep the matrimonial home, how savings, CPF funds should be apportioned, how other assets like cars and investments will be divided, what happens to business interests if either party owns a company, and who gets to keep household items, furniture, or valuable personal belongings. If an asset is jointly owned, one spouse may buy out the other's share, or if neither spouse wishes to keep it, selling the asset and dividing the proceeds may be the fairest option. For high-value assets like properties, businesses, or investments, it may be necessary to get them professionally valued to ensure a fair split. This is particularly important if one spouse intends to buy out the other's share. Both spouses must also make full and frank disclosure of their financial situation. Hiding assets can result in legal consequences and lead to a contested divorce if discovered later. In addition, matrimonial debts must also be discussed. If a home loan is still outstanding, the couple should decide who will be responsible for the mortgage. If there are joint debts, they must determine whether they will be repaid jointly or split between the parties. If neither party wishes to keep a particular asset, the best option may be to sell it and divide the proceeds. Discussions about dividing assets can be stressful, but they don't have to be a battlefield. To keep discussions calm and productive, approach them logically rather than emotionally. Treat the division of assets like a business negotiation instead of a fight, and avoid bringing in past conflicts that could derail discussions. Instead of focusing on winning the most assets, consider what is practical for both parties in the long run. For example, if one spouse cannot afford to maintain the matrimonial home, selling it might be a better option. If disagreements arise, mediation with a neutral third party like a family member can help both spouses reach a fair compromise without going to court, which is cheaper, faster, and less stressful than litigation. If children are involved, both parties should act in their best interests and avoid unnecessary conflicts over assets, as this can create stress for the children. Once an agreement is reached, it should be put in writing so that both parties are clear on the terms. In many cases, how a couple handles asset division determines whether the divorce will be smooth or full of conflict. If asset division is settled amicably, the divorce process will be faster, less expensive, and less painful. However, if it becomes a major dispute, it may result in a contested divorce and further court proceedings, which are time-consuming and costly. The key takeaway is to communicate, be fair, and think long-term. It's not just about getting the best deal today and the most assets. It's about ensuring a stable future post-divorce. If you found this video helpful, please like and subscribe for more legal insights on family law and other topics. If you have any questions, leave them in the comments below. Thank you for watching, and I'll see you in the next video.